As for extension, that was filed on the, let's see, I believe it was filed on the 30th of November. Following review, I issued an initial order, and that was notification to, actually, no, I misspoke. So the extension on which we are meeting today was actually filed on December 11th of 2024. I was making reference to one of the original dates. And following review on the 12th, I granted an initial order of extension for 5 years. Obviously, that was notification to Mr. Tangway for purposes of notifying him of that request, and he filed a timely objection and a further objection as well. If I could please, I would ask the parties to identify themselves for the record, starting first with Attorney Ames.
Yes, good morning, Your Honor. Attorney Heidi Ames for the plaintiff, who is to my left.
Thank you very much. Okay, sir.
Thank you.
Robert Tangway, the defendant, Your Honor.
All right, thank you very much. All right. And for the record, this is case number 656-2022 DV 461. We have an hour set aside for the hearing. That should be sufficient, recognizing that we are addressing only the issue of the extension specifically. Are there any preliminary issues to be addressed? I know, Mr. Tangway, you had submitted an advance request to be able to make a recording, so I'm aware of that, and we shared the copy with Attorney Ames. And I'm not aware of any other preliminary matters.
Your Honor, that's incorrect. What you're sitting on is a motion and notice of judicial and professional misconduct.
This is not the proper forum for that, sir. This is a trial hearing.
Your Honor.
This will be on the hearing on the motion for extension. We are not getting into personnel issues. That is inappropriate. That goes before the JCC.
Your Honor, I'd like you to respectfully take judicial notice of Rule 38 of the New Hampshire Supreme Court, 2.15.
I don't know what that is.
Okay,
I'm not going to address that today. We're going to talk about the extension as is permissible under 173B:5.
That's so you have not provided the reasons for granting the extension upon written request.
Sir, that is what this hearing is for. It was an initial extension. You have a right to object. Okay? I can then, all of the evidence that I received today can make a determination as to whether there is good cause to grant the extension, and if so, for what period of time. I did so initially based upon my reading of the file. You have a right to object, and under the statute and the case law, the court can dismiss the case, the court can deny the request, the court can take all kinds of action. It has that discretion in this forum. So it is today's day after a hearing that I need to make written findings and my reasons for those findings.
Your Honor, I respectfully object to that basis, because if you read 173B extensions, the court shall review the original order of protection.
That is not what is stated under the case law, sir.
That doesn't matter what the case law is. It matters what the state, what the law says, and the court has provided no case law to distinguish the fact. Furthermore, you just said that you don't know what Rule 38 of the New Hampshire Supreme Court.
I'm not as well versed in things by the numbers. Now, again, we're restricted to what we are addressing here today.
Right.
And with all due respect to you, case law is most important because that guides this court as to how it can interpret the statutes. That is the guidance from the New Hampshire Supreme Court. And I will review that law, which is relevant material on this score.
Okay, Your Honor, I would like you to respectfully read the petitioner's request to the court.
I have read it, sir, and I'm not going to read it aloud for the record because it is already part of the record. Please sit down and we'll proceed.
Okay, I would like to respectfully note my objection to the accordance of the judicial codes of conduct, reporting judicial misconduct and professional misconduct, which is in the pleading that you just recognized that you have before you.
And this is not the forum to address that, sir. With all due respect.
I
note your objection for the record.
Thank you, Your Honor.
Attorney Ames, your client is the moving party.
Yes, thank you, Your Honor. I would like to call Irate to the stand, please.
If you're more comfortable sitting there, you may. Okay.
Yeah.
The microphone in front of you is more for recording purposes rather than amplification, so you do need to keep your voice up. acoustics here are terrible, I don't hear very well, so if I can't hear you, I'll ask you to repeat yourself,
Please
okay?
do. Yes,
And I would just ask that you keep your voice up as well.
absolutely.
Okay, Attorney Ames, did you want me to swear in your client, or would you like to?
You can swear her in, Your Honor.
Okay, do you swear from the information you will provide to the court today, be it yourself or through your attorney, is true to the best of your knowledge and belief?
I do.
Okay, and state your name again for the record. Thank you very much, and spell that last name. Okay, thank you very much, Attorney Ames.
Those were my first two questions, Your Honor. Name and spell the
Each
last name. Do you and the defendant have children in common?
Yes, we have two boys, Robbie and Ethan.
How old are they?
Robbie is 8, Ethan is 5.
And in 2022, did you file a domestic violence petition in this court?
I did.
Why did you file it?
I was very, very scared. Mr. Tangway's personality and everything really changed after I broke up with him. He was very mad that I broke up with him. He was very mad that I started dating someone new. So it'd been a year since we had broken up, and he was still texting me multiple times a day, every day, calling me, emailing me. It got to the point where he was only to come to my house to pick up the kids, and he would still try and enter my home after I asked him not to. I asked my lawyer to send him an email asking him to not enter my residence, and he would still enter my residence at times. He would go into my car and not leave when I asked him to leave. Just showing up at my house unannounced.
I don't know as if we need to spend much more time.
Okay, understood. Yeah.
I am familiar with the file, I did go through the pleadings
Okay.
and orders.
And was that domestic violence petition granted on an emergency basis?
Yes,
And then was it granted on a final basis?
yes,
And did the defendant appeal that decision?
yes,
And was the decision upheld by the New Hampshire Supreme Court?
yes,
And in December of 2023, did you file to initially extend that order of protection?
I did.
And in 2023, briefly, why did you file to extend the order?
Although he did follow it and he wasn't contacting me directly, he was using, I feel, the court system to still harass and abuse me through litigation abuse. He wasn't paying child support, so there's a financial abuse of leaving the burden of raising both of our kids completely on my own because he wasn't seeing them.
Objection, Your Honor. Foundation.
Basis?
Foundation.
Rules of evidence do not apply in these proceedings. The court can admit what it deems most relevant and material. Please sit down. Ruled.
Also, his YouTube videos, that he was just irate at our parenting case. He has gone to the chief of police trying to get me arrested. He said I kidnapped the kids for taking them on
Objection, Your
vacation.
Honor.
Basis.
Speculation and misleading. I was not
Rules
irate.
of evidence do not apply in these proceedings, sir. This is relevant material for what I have to determine.
Okay.
We're not gonna spend a lot of time on the past, because I need to look forward as to whether there's good cause. Please sit down, sir.
I was just still scared.
Thank
It
you.
seemed like his
I
behavior,
note your objection for the record.
I feel like his behavior was just elevating versus decreasing, and I was even more scared at that point.
Was that initial extension granted?
Yes,
Okay. And was a final order issued in the parenting case? And did Mr. Tangway appeal that parenting order?
yes,
And do you know, we have exhibits, Your Honor, but before I even submit them, I've already provided them to the court,
I
but
see that.
before we even submit them, do you know how many pleadings were filed in that case?
a total of 71.
How many were filed by you or your attorney?
3.
How many were filed by Mr. Tangway during
Sorry,
during the Supreme Court case only?
Supreme Court, 47.
Did you feel that was excessive?
Yes, a lot of them are repetitive too.
Okay. And during the past year, has Mr. Tangway contacted relatives of yours?
And may I just interject, and this
Sure.
is for both parties. Both of you have submitted exhibits. Just because you have submitted them to the court, you have filed them with the court, just because I have them does not mean they're entered into evidence. So if there's something in particular that you want to point the court's attention to, I expect you to come up and to select that exhibit, identify it for me, and then I'll ask for you to explain to me the relevance or what you want me to take from that. So, Mr. Tangway, those are yours, and Attorney Ames, these are yours. And
Thank
I
you.
will staple and mark as they are submitted. I
Thank
just
you,
need
Your
to
Honor.
know the basis for those submissions.
Sure. I'm just gonna pull out. Your Honor, I would like to move to submit Petitioner's Exhibit 6, which is the outline of the pleadings filed in the New Hampshire Supreme Court case, which occurred within the past year.
Okay, let's set that.
Your Honor, I would like to respectfully object. These were not provided to me prior as well. She did send them to me, I think it was yesterday, or went into court yesterday after I told her, if you note the time that they were submitted to you, which shows the conduct of Attorney Ames, and she didn't even notify me of the extension request, knowing that I was
Sir,
home.
she doesn't have to notify you of the extension request. Okay, so I note your objection for the record. I'm going to accept it because it is relevant.
Okay.
What I have to determine, sir, your objection is noted for the record.
An additional objection to that, if that is the case file, that I note that all the files that are filed in the Supreme Court also be noted, because it's.
I don't have jurisdiction to do that, sir. And let me hear from Attorney Ames. Attorney Ames, when did you cause to be delivered to or send these exhibits to Mr. Tangway?
Thank you, Your Honor. They were sent to him on Monday afternoon, and he confirmed immediate receipt within 5 minutes of receiving them.
Okay, so that's more than 24 hours. I find that's fair.
She hasn't provided paper copies, and she did that.
Sir, there's no requirement for paper copies. You had notice of the exhibits.
Okay.
I find that that is what I need to determine. You may have a seat. Thank you.
Your Honor, just to be clear, Mr. Tangway specifically asked in all pleadings that he be sent correspondence through email because he is homeless. So there was no address to send them to. Otherwise, I absolutely would have sent a hard copy to him.
Thank you.
Your Honor, I'd also like to take note that if the court notes that her objection to my motion to dismiss, she swore that she emailed me on the 10th, which she did not. She emailed me on the 13th after I contacted the court.
Okay.
So this just goes into the nature of what I've always contended, that Attorney Ames has brought
This
this
is not a
motion.
misconduct hearing, sir. This exhibit is going to be admitted. I find that you have been provided notice of them. You've had an opportunity to read them.
Again, Your Honor, you have a duty, respectfully, for any information of judicial or professional misconduct to report it, and to failure to report so is also judicial misconduct.
I'm aware of that responsibility, and I will do that in my own good time. Please have a seat.
Thank you.
I marked, what is marked as your Exhibit 6 is Petitioner's 1.
Thank you. During this time period in the last year, did Mr. Tangway contact your family members?
Yes, he contacted my father and my brother.
How did he contact them? What method?
He left a voicemail for my brother, so called him and left a voicemail. He called my father twice. He left him 2 voicemails, and he also sent him some text messages.
I'm gonna have you look at Exhibit 1. Do you recognize this exhibit?
Yes, it's a transcript of the voicemail he left my brother.
Okay, I'm gonna have you look at, briefly, Exhibit 2,
Voicemail left my father.
Exhibit 3,
Another voicemail left my father.
Exhibit 4,
Some text that he sent my dad.
and then Exhibit 5.
Another text he sent my dad.
We would like to move to put these into evidence.
What was the time frame during which those were received?
It was like August, September
Of
of
2024.
2024. Yeah, 2024.
2024?
Yep.
Yes.
Okay.
This year.
Yeah.
I wanted to make sure I've got the-
Your Honor, I'm going to respectfully object as to probative value. This will, at this point, there is, if you've noticed that the protection order does not provide any inability to contact or communicate with family members, and I think that will bias Your Honor more than it will have a probative value. I am clearly able to contact anyone I choose except for Miss Andre, and in fact, there's conflicting orders in the court, in this court, which has been brought up time and time again.
Orders have been previously affirmed and the appeals denied, so we're not going backwards. What I will say is the only way for me to make a determination as to the substance of the content, whether or not they're appropriate or inappropriate, is for me to read them. And I do know that the statute does allow for some contact, but it also goes to the nuances of some of the language, maybe the number of communications and the purpose of the communications. So those are all factors for the court to consider as to whether or not there may be arguably a violation, perhaps not. But even so, for an extension, the court does not have to find that there was a subsequent act of abuse. In fact, the court need only find good cause.
Right.
And that is what is stated as per the case law. So that is why I think I'm going to admit these, because I find them both relevant and material for what I have to decide in the big scheme of things.
That's fine. I'd like to also note that the case law provided by this court also says that in the instance of fraud or any misfact, that the hearing did not actually take place. Res judica.
Sir, I respectfully disagree. That has already been litigated, both in this case and in the marital case, and we're not gonna hear fraud again. Okay, we're talking about the extension and the basis therefore.
Your Honor,
not the basis of what was granted in the past or further extended.
you must, by 173B extensions, you must look at the original order in order to extend it. You must look at the original.
Understand the context, sir. Understand the context. I am not going back to revisit whether or not my colleague properly granted or denied that. I'm not going to do it because the Supreme Court didn't do it, and you took it all the way up. So you had every point of redress there, so we're not doing it again. And I'm not gonna say it again. So your objection is noted for the record. Please have a seat.
Why did you, I'm sorry, strike that. Did you file on December 11th to extend the current order for 5 years, or to extend the domestic violence restraining order for 5 years?
Yes, I did.
And why did you do that?
Again, I'm still fearful. I'm scared for my safety. I believe that if it was not in place, he would 100% directly contact me and show up at my house again, and maybe even more.
Do you monitor Mr. Tanguay's social media and video postings online?
From time to time, and also family and friends do for me as well.
Why do you do that?
Just to see where his mental state is at, see how his behavior is.
And I'm gonna present to you as Exhibit 7, but before I want you to identify it. Do you recognize this screenshot of a YouTube page?
Yes, it's Robert Tanguay.
I might have some in my bag, Your Honor.
I had some.
I usually carry it with me.
Do we have both?
No.
Oh, okay, I have petitioners, that'd be fine, thank you.
Thank you.
All right, thank you very much for the offer. So,
So do you recognize the videos that are listed on there?
Yes.
And what are they?
Bobby going to lots of different places and trying to claim that he's a person, a victim of domestic violence. He's also gone to the governor's office, him going after the police for not arresting me, saying I kidnapped my children. So a lot of our court proceedings are even posted.
Time frame?
So some of these are last year, but he has posted, new ones this year.
Well, last year, this year, I'm
Just
thinking in terms of, you could give me
recently.
roughly the month or time of the year. I understand that extension granted by Judge Joseph was granted in December of 2023.
So there's a video from a month ago, there's two videos from 2 months ago. A video of him at the police station 3 months ago.
So within 2024.
Oh yeah, there's a handful of videos just from this year.
Your Honor, may I submit this as Exhibit 7?
Okay, that will be my exhibit 3. Thank you.
In addition to lengthy videos, does he post short videos or shorts?
Yes, he does.
Can you explain briefly just what shorts are?
They're just usually a minute long or so of, sometimes it can be taking original video and shortening it down, or it's just recording on a short video.
And so I'm gonna put in front of you Exhibit 8 for identification. Do you recognize these videos? Or shorts, rather. I'm gonna call them shorts because they are distinguished from videos.
Yes,
And were those posted, some of those posted within the last year?
yes,
Were some of them posted within the last 6 months?
yes.
And what is the substance, if you could summarize the substance of the videos?
I mean, they're all over the place at times, but again, trying to get me kidnapped, some conversations with, he's had police officers, it's him,
Just to clarify, to get you arrested for kidnapping?
yes.
Not trying to kidnap you?
Oh, yes, sorry.
Okay.
And, just him saying how fraudulent he feels this DVO is, and our situation and the parenting case and all of our court cases.
In this material that he posts, does he include recordings of these hearings?
Yes,
Does he include your name sometimes in those videos?
yes, he has.
Does he include the name of your legal counsel, parents, or friends?
Yes, where it says the mother for me.
I'm gonna submit this as Exhibit 8, Your Honor, formally.
And that will be court's 4.
So you filed to extend this on December 11th, we've established, correct?
Yes.
Was there, after filing this, was there a recent social media post that caused you concern?
Yes,
Can you tell the court about that?
it was on Twitter, or what's now called X. He posted a video of someone starting a fire, like the LA fire, it was in LA, changed the LA fires.
Do you know, I'm sorry, I'm gonna interrupt you, do you know what day this was?
Yes, January 9th, the day that he filed his exhibits.
And what did the,
Your Honor, I'm respectfully going to object as to the context of this. She's providing screenshots of a post allegedly that I posted, and not any of the comments or the video itself. So all this video evidence, we could easily look it up on this monitor, which I've requested right here, and
I
watch
can do that on my own time, sir.
Oh,
I'll use this as a point of reference, should I choose to do that, thank you.
that's appreciated. Thank you, Your Honor.
I'm gonna put in front of you an exhibit. Do you recognize this exhibit?
Yes, this is his X account.
And for the January 9th post, what did he write?
It's not right. So he said, this is what happens when there's no hope. They want it all to burn, or something to that extent. And then if you clicked on it, he also commented, directly on the post.
Your Honor, just for the record, I'm putting the exhibit in front of her so she can see it.
Right.
And it went directly on the post. He said that's because people are forced to live on the streets, so it doesn't matter to them. No hope in it. You get this.
Is Mr. Tangway currently homeless?
Yes,
Is he currently living on the streets?
yes,
Did you take that as a threat?
I did. He blames me for everything, for losing his marketing job, for not seeing his kids, for having to pay child support, and for now being homeless.
And do you think without this order of protection, you are safe?
No, I don't. He continues to harass me again, like through all these different things, even threatening civil lawsuits. And if it's not in place, so when he was younger, he went to jail, and he told me he would never ever go to jail again. He would not do that. And I think that is the only thing that's stopping him from contacting me. If he doesn't see his behavior as wrong or bad or as harassment, and the only reason why he's not contacting me is because he doesn't want to be arrested or go to jail.
So in conclusion, why are you asking the court to extend this for 5 years? So we're gonna talk about the duration. You have asked for the full length of 5 years.
I feel like it's been 2 years, and that his behavior has only escalated over these 2 years, and it has gotten worse. I think that's best for my well-being, and for my mental state. I'm still very scared. I still look over my shoulder. I'm still worried he's gonna show up at my house. I still lock my doors, keep pepper spray on me. Although this has helped and put some ease to the situation, but just seeing how hostile he's been to my lawyer, my parents at times, even clerks or other people, it makes me really nervous.
Your Honor, I realized I didn't submit exhibit, I think it's gonna be the court's 5, is that correct?
Yes.
Which is the Twitter/X platform.
Thank you.
Your Honor, I have no further questions for the plaintiff. Thank you.
Just give me a moment, Mr. Tangway.
Thank you.
Did you have specific questions on cross-examination?
Yes, Your Honor.
Okay. You may do so from the seated position if you'd like. I would just ask you to keep your voice up.
Thank you, Your Honor. You just stated that you are, that's what your name is. You just stated that,
You could please call her Ms. Andre.
okay. Your Honor, I think that she, in her exhibit list, she calls herself,
Sir, I'm not gonna debate it with you. I think it's more professional, and that's the way I would like to keep it.
okay.
Thank you.
Noting that I would like to, I will follow your rules the best I can. However, it dehumanizes the relationship that we actually have. So
My focus is on whether or not there's good cause to extend.
I understand.
Okay.
I'm considering that she's not a credible witness because of the fraud that's been going on.
That is argumentative, and I'll strike that.
Okay. Sorry, Your Honor. I'm trying the best I can. Ray, you were in a relationship with Daniel Daw, correct?
I was, yes.
Okay. And he was a police officer.
Your Honor, I'm gonna
How is
object.
that
How is
relevant?
it relevant? Yes.
Your Honor, first I'd like to bring to the court's attention,
That's not relevant, sir.
you're acting as counsel. But it is relevant. She just testified that she had a boyfriend. And
If I may, sir, I just
and
wanted
that
to
the police.
correct the record. I'm not acting as counsel. I am trying desperately to keep this to a time frame because I have hearings this afternoon.
Okay.
Okay? So I have discretion in order to try to keep these hearings tight. So I'm not going to go down the road that is completely irrelevant and immaterial. So I just
Your
want to
Honor, I
correct the record on that, sir. So please keep it to the task at hand.
Yes.
What is present? Anything within the last year, if you'd like to address that.
Anything within the last year? Okay. So you had a boyfriend, he was a police officer, and that ended.
Your Honor, again, I'm gonna object, and it's no relevance.
Stricken.
Thank you.
It is stricken,
How does
Mr.
it not
Tangway.
have relevance?
Mr. Tangway.
She just
Are you
testified she had a
gonna spend
boyfriend.
your time doing this? I'm gonna give a half an hour to each. Attorney Ames has already submitted her direct.
I asked for 4 hours.
And the court can't accommodate that, sir.
Yes, it can.
Especially if we're going down paths that are immaterial and irrelevant. If you stay on task, we will get the hearing in. We're wasting valuable time on frivolous things.
I object to that.
Objection noted.
Miss, you said that I contacted your parents, correct?
Yes.
Okay. And were the police called in at any point for that?
Yes, you called the police on them.
Were the police called by them?
Nope.
Okay.
They called the police back.
Okay. As you are aware of, contact with anybody but the protected party is completely permissible.
Your Honor, is that a question? Can he
Yeah,
refrain?
can you rephrase your question? I want to understand it. It looks like you're mixing it with a statement of law, and if you're going to do that, it needs to be accurate. So if you could just rephrase your question, please.
You've seen the protection order, correct?
Yes.
And on that protection order, does it refrain me from talking or communicating with your friends or family?
No, but I just found it harassing.
Your Honor, asking her to. She is going beyond.
You ask a question, you get an answer.
Yep.
You need to accept the answer, and let me just go back to the original order. I just want to clarify one thing, because I know that there is a paragraph that may pertain specifically to that, or at least relevant on that score. Hold on. Hold on, please. I'm referring to paragraph 6, and this is in the original order, index 12. The defendant is restrained from abusing plaintiff's household members or plaintiff's relatives, regardless of their place of residence, or engaging in any other conduct which would place the plaintiff in reasonable fear of bodily injury to the plaintiff or the plaintiff's household members or relatives.
Yeah. Yes.
So that is part of the order.
Right. Bodily fear, which is what domestic violence is, Your Honor.
That is incorrect, sir. That is not a statement of law.
Knight versus Miller, the Supreme Court, New Hampshire Supreme Court in 2011 clearly stated imminent threat of bodily harm.
The Supreme Court can make that determination, sir. Let's not spend any time on that. Okay? It is a question of law, and that is something that I have to determine in interpreting the law as written.
Okay.
So I don't need you to restate the law to me. Why don't you finish with your question?
My question was very simple. On the protection order, is the defendant prohibited in any which manner from talking to anybody else besides Miss Irate?
Yes, in the article which you just read.
Could you please reread that, because in no way does it say that I'm not allowed to. It only says abuse. Is that correct?
Your Honor, can the court take judicial notice of what the...
I will take judicial notice of the way that paragraph 6 reads in the order that was issued by the referee, Art Maloney, and affirmed, or at least approved by Judge Cabrera.
Okay. So it does not say that I'm allowed to not contact your parents, correct?
Your Honor, I believe that question was asked and answered.
It has been asked and answered.
Okay.
Let's move on, sir.
And on that same order, it says that I initiated 1,100 texts to the plaintiff.
Your Honor, I'm going to object. This is about the order from back at the
We're not
original
going
order. We're not
backwards.
relitigating. Thank you.
That's why I asked you to stick within post December, if I may.
It's 2023.
Yeah, so she reaffirmed the initial order for the extension.
I'd like the court
Let
to
me,
note
so
that I am
post, if I
constantly
may, sir,
interrupted.
if I may, subsequent to December 4, 2023 to the present. That will help
December,
stay within what is necessary for purposes of considering, unless there's something remote that
Right.
is directly related to something else that happened in 2024.
as the court knows, that upon the filing of a court order, the clerk has to sign it to make it a writ.
Mr. Tanguay, is this
And-
argument, hold on, is this argument? Because this is
No.
your opportunity to ask questions. I will let you make argument at the end, please. You can save that thought.
So you're trying to cover, it is apparent that you're trying to cover up the orders which you guys have. So
I'm
the,
gonna object to this. This is again an argument, not a question. This is cross-examination.
it's not an argument, just because you're.
Mr. Tanguay, she's making her objection to the court. What is your response?
My response is not an argument. The court just pulled up, excuse me, if I may speak without being interrupted, kindly. Thank you, Your Honor. The court just brought up the original order by Referee Maloney. I've told this court that 173B's extension says that the court shall look at the original order. Then they have to transmit it to the police with the signed clerk to make it a writ. That happened on your account, the court's recollection, December 12th, 2024. Further, you've accepted evidence from January 2025 on the court record. So we're simply pulling up the original orders, which Your Honor respectfully has a duty to review before you granted the extension. You already granted the 5-year extension on the 4 sentences that she claimed. And now she's bringing in all this new evidence.
Okay, can I stop you right there?
Yes, Your Honor, thank
Okay,
you.
I did suggest that you hold your argument until the end. So you're still on cross-examination. This is an
Right.
evidentiary hearing. Why don't we do that, and then you can spend time on your argument, because at the rate we're going, you're not gonna leave yourself any opportunity to present any evidence.
I don't want this hearing is not sufficient for the allegations. We should be here only on the motion to dismiss, not proceeding with this, because Your Honor has not given me the reasons for granting the extension as required by law 173B. And what I was just doing was responding to her objection. Her objection was that this is not on the record. This is on the record. The court has this in front of them. I've submitted this. I have from the police as well. I've also.
Do you have any more questions on cross-examination?
Yes, Your Honor.
Why don't you ask those questions and we'll get to argument later.
On the order of protection, which I claim is fraudulent, which you've mentioned is fraudulent, does it not, excuse me,
That comment is stricken, and you're not going to talk over.
she just
Sir?
she just interrupted me.
She tried to object, because you keep doing that, so please do not do that.
Object.
That may be your opinion.
Object to what?
So any reference to fraudulent orders will be stricken from the record. Ask your question.
Okay.
Without editorial comment.
Sorry, Your Honor. So she claimed that I said that the order was fraudulent. So I'm simply using her testimony. She said that they're fraudulent. I claim that they're fraudulent. And I'm trying to explain to her. I'm objecting to her testimony as legal, as she is incompetent. She is not an attorney. She has no legal.
Is this a question?
The question is, on the orders for protection by Joseph Maloney, which have been refiled over and over again, including on this extension hearing, does it not say specifically the defendant committed said abuse when he initiated 1,100 texts to plaintiff in September 2022, same again in October and November 2022, in addition to 52
Mr. Tanguay?
phone calls.
Mr. Tanguay, I'm going to instruct her not to answer that question, because you're going back in time again, and we're not going to do that. that has already been litigated, decided, the appeal was denied. Please move on.
Your Honor, the whole point of the judiciary and appeals process, and also Rule 38.
Save that argument for later. Questions?
The question is, the extension order that she claims, that I claim is fraud. Why do you think I claim it's fraud?
Your Honor, I'm gonna object to this question because it's asking her to understand and interpret his mind and his opinion.
Calls for speculation.
It's speculation at this point.
Your Honor.
And you can explain that if you wish during your argument. Any other questions?
Your Honor.
Try to get through cross-examination so you have an opportunity
You're not
to
allowing
present
me.
evidence.
You're not allowing me to cross-examine, and you're saying that.
You're not asking questions. You're arguing. Questions, please.
I just asked a question. You're not letting me ask any questions. You're protecting
I'm
the
not
witness.
protecting.
Yes, you
You are
are.
asking argumentative questions. That one called for speculation. How would she know what's in your head?
Exactly. Miss, what's in Robert Tanguay's head?
You can answer that. I don't even know what to say anymore, Your Honor.
That's irrelevant. Please move on, sir. You're,
So Miss Lane, that you're afraid of what I'm going to do next because I am mentally disturbed, or a summary, or like, please state why you are afraid of me. Why are you afraid of me?
Your behavior is extremely erratic. You blame everyone else for anything that happens. You don't take any responsibility for your actions. You don't think anything that you have done in these last 3 years is wrong. And I'm not the only one that's nervous. 3 other people have called the police on you. 4. You have trespassing orders against you at the governor's office, the New Hampshire Coalition.
Your Honor, that's misleading. I do not have.
sir, you
Okay.
asked a question. You got an answer.
So how do you know I have trespass orders at the?
Sir,
I'm asking her a follow-up question.
we're not
So
going to spend too much time on
how
that.
do you know that I have trespass orders at the governor's
Videos.
office? The videos do not have any trespass orders.
Please don't argue with your witness. You get the answer you get.
So the videos that you're saying you submitted to evidence show that I have a trespass at the governor's
There was a letter
office.
attached to the thing saying you were not allowed to go there anymore.
What was also attached to that letter?
I don't know. It's been a while since I've read it.
Okay.
Watched
So these videos that you're so afraid of, have you called the police at all about your fear for a crime being committed?
I have the protection order. I feel like I am protected right now with the order in place.
How does a protection order protect you?
You're
Your
not
Honor,
directly.
I'm gonna object to, thank you.
Again, let's ask for specific questions.
Okay.
You may save that for argument.
I'm going to object to the, I have not been afforded the ability to cross-examine the witness. You're not allowing me to bring in any,
I'm not allowing you to argue with the witness.
I'm not trying
You
to,
may ask questions,
every time I ask a question, I get an objection.
because they're not all straightforward questions. Many are argumentative
Okay.
or
So
speculatory.
has Robert Tanguay ever physically hurt you?
He pushed through my front door when I was standing in front of it,
When was that?
in 2022.
Did you call the police?
No,
Why did you not call the police?
because I had my children to consider. Didn't want them to see their father being arrested.
Okay. And do you have any video recordings of that?
I did, but it's gone.
Respectfully, that has already gone into evidence, been reviewed, determinations made. We're not going to go backwards, Mr. Tanguay.
Well, again, I would like to object, res judicata,
Your
provide.
objection's noted for the record, please
Okay.
move on.
So, you don't know when he alleged those things, when you alleged that happened?
Your Honor,
In
I-
2022.
Okay, 2022 is a very,
That is as far as it's going to go, Mr. Tangway.
okay. Did Robert Tangway in any communications ever threaten your safety? With physical violence?
When? Is there a time frame?
Did he ever do that? No?
Oh, can you just respond verbally? You can't, the record doesn't reflect that you shook your head. So you're saying, no, you're not putting a time frame on that?
That is in our relationship. Yes.
Okay, so you're just saying ever?
Yes,
Okay.
ever.
I'm just looking for the
Yeah, ever. Did he ever threaten you physically?
Not that I recall.
Okay. So he never threatened you physically. Did you ever call the police on Robert Tangway at all?
That's been asked and answered.
She did not answer it. May I remind you?
If you can answer it, ma'am.
No,
go
I
ahead.
have not.
Okay, if I may remind
I
you.
have gone to the police due to your actions and talked to them,
Okay.
and they're the ones that suggested I get this restraining order. Originally.
Excellent. Please note for the record that the police have suggested
One of
that
the
you.
many people that have been called.
Please note for the record that the police suggested that she get a restraining order.
I hear that every single day of the week,
Okay.
okay? So it is noted for the record,
Your Honor, they just laughed at me.
because it's an obvious observation, sir.
Wha-
Every day of the week, I have someone coming in both the DB context and the civil context, saying they were encouraged to consider getting a protective order based upon conduct which caused them alarm.
Okay,
Okay, that's an observation, sir, one that I made.
okay,
Okay,
so,
that's all.
Your Honor,
So please, move on.
Your Honor, I don't like the tone that you're giving me. Respectfully, as part of 173B, in order to get a protection order, you must have been found to commit a crime. So if she went to the police to,
I disagree with that. That is a misstatement of the law. That is stricken.
okay, that's,
Okay, please move on. If you have any other
Okay.
questions, because you will not have time to present any evidence at the rate you're going.
all right, let's get into that.
Okay, so hold on. Any redirect?
you indicated during cross-examination that there were no threats to your physical safety.
Excuse me, I didn't give up my redirect.
Hold on. I told her she could ask questions on redirects, and she said, now let's get into that. I assume
I
that you were
can
going into
put-
your case in chief.
I was gonna submit some evidence, I'm not.
No, if you are, that's your case in chief. I'm just giving her an opportunity. That is generally the procedure we follow after a cross-examination. Redirect.
Yes, he did not threaten your physical safety, is that what you testified?
Correct.
Did he threaten to file a lawsuit against you?
Yes, he has.
Did he threaten to have you arrested for kidnapping?
Yes, he has.
Has he threatened to have the kids taken away from you?
Yes, he has.
No further questions, Your Honor.
But,
Okay?
wait,
So-
excuse me, I wasn't done examining the witness.
Sir, you said, now let's get into that. I thought you were referring to
I already
the
told you, no, I
case.
said no. Just calm down.
Your Honor, I'm gonna move to have this hearing be concluded. At this point, Your Honor, we have asked
No.
and given Mr. Tangway the opportunity.
I will give him the opportunity. Now he squanders it. That's gonna be the end of it.
Understood, okay, thank you.
Okay, Mr. Tangway, this is your opportunity to present evidence in support of your objection.
Right.
And then I will allow you to make argument.
You haven't, okay. Petitioner filed I'd like to enter Exhibit A, a motion for contempt of the court and affidavit of fact.
Okay, so, is that a,
Hey, don't approach.
Oh, sorry.
Don't approach.
the court officer,
Calm down.
he's here at the ready. Okay, so
Your Honor, what
Oh.
case was this filed in?
it looks like it's pocketed in the Supreme Court. No. No, that was already determined. It's a pleading, sir, that's all it is a pleading.
Listen, Your Honor,
That is not evidence,
Your,
sir.
what are you talking about? It's a document, Your Honor.
It's a document that you wrote.
You just accepted her evidence. You accepted. Look at her face.
I
She's
accepted
frustrated.
posts.
You accepted a screenshot of the Supreme Court case. I have the actual document of one of those filings, and you're not accepting it.
Okay, I'll accept it. What weight, if any, I give to it? I'd like to draw the court's attention and the witness to Exhibit A. Miss A, correct?
Your Honor, I was under the impression that cross-examination was over and he was presenting
Process
his...
over. This is your opportunity for your case in chief, Mr. Tangway.
I didn't say cross-examination
Well,
was
you
over.
have no business then sitting and looking in that direction. If you're going to present evidence, please present it to the court.
Okay. I'm
So I have
examining,
accepted your exhibit.
okay, and
What
so I'm
next?
asking, I provided this to the court and to Miss Attorney through the court.
There's no need for a response from them. Why don't you present your case to the court, please?
You're stopping me from cross-examining the witness?
The cross is over, sir. We've already done redirect. This is your
I
opportunity.
didn't- I-
This is your opportunity.
I object to the redirect.
Sir,
You're, okay, so if,
I am going to conclude the hearing unless you move along.
I would like to call Erica Andre as a witness.
No. For what purpose?
To the purpose to go through the evidence.
No.
Why?
You can present, actually, why don't I do this? Raise your right hand, sir.
I am not,
Raise your right hand, sir, if you want to present something factual. Do you swear affirm the information you will provide to the court today is true to the best of your knowledge and belief?
so help me God.
Okay. All right, Mr. Tangway. Present the evidence that you wish to present. You don't have to present it through anyone else.
So Exhibit A, you'll find that it is the motion that has been filed with this court and also the Supreme Court. It is an affidavit of all the things that are wrong in this case.
That has nothing to do with whether or not there's good cause for an extension, sir. But if you want to go down that road and waste valuable time, you're welcome to.
You have not allowed me to continue to cross-examine the witness and object to Heidi Ames' last statement saying that I was filing a lawsuit. Like, it's just nonsense what's happening
So
here.
please present, this is your opportunity to present evidence. I'm not going to say it any more than I already have. Please. You wanted 4 hours. You're not doing anything with the time that you have. Please present your
You're stopping
case.
me.
I've stopped you from arguing, sir.
Your Honor, my case is really simple. That I have been retaliated against by the court and Miss Ames. At the beginning of the onset of this case, I filed everything appropriately and responded to everything appropriately. There was no DV in place in September of 2022 when the petitioner, plaintiff, filed a parenting petition. The court did not give order mediation.
Sir, we're not relitigating that case here.
She says in her filing that I think that that these hearings are fraudulent. That's what she's saying. That's what you granted, Your Honor, the
Sir?
petitioner. You did. You signed it, the extension.
I'll give you until 11:30.
Okay. So again, we started this. she filed a petition in September of 2022 after breaking up with Daniel Daw, the police officer. Prior to that, I called the Manchester police and
I'm sorry, sir, if you're gonna spend all your time in 2022, the hearing is going to be concluded.
I'm not going to spend.
My focus, and I've said this time and again, is whether or not there is good cause that has occurred in the course of the last year, December 2023 until the present.
The protection order is fraudulent, Your Honor.
Okay.
It contains
Hearing is
physical.
concluded. I've said time and again.
You didn't
It has
get.
already been decided, appealed, dismissed 2 times in the DV and in the marital or the parenting case. And I told you we're not going backwards, and I've said it till I'm blue in the face, and I'm not gonna say it again. So unless you want to present evidence, I will walk
I
off this
want to
bench.
present. I'm presenting this evidence right here. I
Then
presented.
stop talking about 2022.
I'm trying to explain to you, to the court, why the.
We're not relitigating, it's already been decided.
Your Honor, there are orders. The only orders that have come from this court are orders that say that I can't see my children. Then they held me in contempt for not communicating directly with Erica Andre. They held me in contempt. It's all in filings. I'm trying specific.
And those are the other cases.
Well, I'm sorry.
And again, we're not addressing the other cases.
Your Honor.
I
Your Honor, I have filed and attached to those pleadings destroyed evidence of the judge Marconi.
No, we're not going to misconduct. I'm concluding the hearing at this time, thank you.
Please rise.
It's concluded.
Look at her storm
Thank
out.
you, the hearing is
She
concluded.
just stormed out.
You may exit, please.
Oh, she didn't.
Yes, she did.
The record is,
Yes.
Thank you.
you're off the record.